Thank you all very much for joining what promises to be an interesting discussion on the Navtej Singh Johar judgment. We recently celebrated 4 years of the judgment, which was passed in 2018 September. I'm absolutely delighted to sort of be hosting and moderating this webinar. It's our special webinar that we're hosting in two parts, where we celebrate 4 years of the Johar judgment. Today's panel discussion is a little more legal intensive. We have a heavy-hitting panel of lawyers who have significant subject matter expertise in this area and have been involved directly in some shape or form or fashion in this judgment and similar matters in this area. I'm absolutely delighted to introduce today's panelists for our discussion, who also identify themselves as members of the queer community. I'd start with Arvind Narrain. He's the founder member of the Alternative Law Forum. Arvind is a lawyer and a writer based in Bangalore. He's a founder member of the ALF, co-editor of Law Like Love, Queer Perspectives on Law, and co-author of Breathing Life into the Constitution. Arvind was also part of the team of lawyers that challenged Section 377 of the IPC right from the High Court in 2009 all the way until the Supreme Court in 2018. So Arvind, welcome aboard. Delighted to have you join our special panel discussion today to celebrate 4 years of the Johar judgment. Our second panelist is Amritananda Chakravarti. She's a lawyer and partner at Chakravarti, Sampson and Munot. Amritananda is a lawyer based in New Delhi with extensive experience in LGBTI rights, litigation, and advocacy. Previously, as a part of the Lawyers Collective, Ms. Chakravarti has also been involved in several landmark cases, including challenging the mandatory death penalty for drug offenses, removal of the anti-sodomy law, recognition of transgender persons, commutation of death sentences, and challenging the beef ban. In 2017, she started her own practice and runs a law firm, Chakravarti, Sampson and Munot, with two other partners. Presently, she's handling many strategic cases, including challenging the termination of a transgender woman from the Indian Navy, medical negligence, discrimination in employment, challenging educational bylaws that exclude trans persons, discrimination in access to insurance, and seeking reservation for transgender persons in public employment. She's actively involved in public advocacy, research, and regularly liaisons with the parliamentarians and the ministries. Welcome, Amrita. I know that Amrita will not be able to join us immediately because she's actually, as I understand it, in the middle of very, very high-profile litigation that one of which I just mentioned a while ago. But she's promised that she will join as soon as she's able to. So we expect her to be able to join us somewhere around 4 p.m. And our third panelist is Shweta Sangtani. She's a lawyer and co-founder of the Sangya Project. Shweta is a litigating lawyer at the Bombay High Court and co-founder of the Sangya Project, an online initiative to reconstruct common perceptions of sex and sexuality. I'm really excited about today's sort of discussion. I really hope that we can sort of have a discussion that will give a lot of takeaways for those who have taken time out from their schedules to join us and understand a little bit more about the Johar judgment. So I'm going to sort of kick off with asking Arvind, really, who's been, I think, steeped in sort of everything related to the Johar judgment way back from 2009 or even earlier. Arvind, in your view, Johar is obviously a momentous judgment in sort of in the judicial history of independent India. What do you think are sort of the key aspects that were sort of that came out from the judgment? And before Arvind responds, here's a timeline for all of you, which is basically a timeline that shows how from 2001 the battle started. When the NAS NGO filed a PIL in the Delhi High Court seeking legalization to allow gay sex amongst consenting adults. This worked its way through in 2004, where the Delhi High Court dismissed the petition. In 2006, NAS Foundation filed an appeal before the Supreme Court, and all the way until 2018, where we have got to with the Johar judgment. In between, we had the momentous Nalsa judgment, where for the first time, the Supreme Court recognized transgender people as the third gender. And of course, the Supreme Court's famous decision in 2017, the Puttaswamy judgment, where the Supreme Court upheld the right to privacy. And they went on to add that sexual orientation is an essential component of identity, and the rights of the LGBTQ plus persons are founded on sound constitutional doctrines, right? So all of these obviously have had an impact on the final landmark Johar judgment that was delivered in September 2018, which is what we are celebrating here today. So this timeline is there for all of you. We'll make this available as well. So for those of you who want to sort of keep this timeline, you're welcome to download it. It should be available on the Rainmaker website as well. The Johar judgment. I mean, and there's a lot in it, right? And just for all of you, I wanted to also share this. I found this to be very, very useful reading. I know it may not be very clear on my camera because I think I've got my virtual screen on, but it's basically a booklet called Right to Love. That was edited by Arvind and by the ALF, and Arvind was the editor of this document or this booklet. I'd urge all of you to download it. I think it's on the ALF site, right, Arvind?
Yeah.
So it makes for very good reading. It's really a gold mine of information for those of you who are seeking to learn a little bit more about how the Johar judgment came out. There's detailed timelines. There's a lot about each judge's views and judgment, and of course, sort of a comprehensive understanding of how the case was heard in the court and which counsel said what. All of that is there in this. It's a must read in my view. Strongly recommended to all of you if you haven't already gone through it yet. So back to you, Arvind. Your thoughts on what are some of the key takeaways? And there's a lot typical of the way our judiciary functions. A lot of the concepts are heavy and may not necessarily translate easily to non-lawyers. So if you could just share your initial thoughts in terms of what the judgment really is trying to say, and then maybe share some more nuggets in terms of what each of those specific points or features are that we could share with our audience.
Yeah, thank you. Thanks, Anthony, for having me on this particular webinar. And you asked me what were the key features of the Navtej judgment. And I think it perhaps makes sense to take one step backward and think a little bit about how sometimes it's very difficult for most people to speak about issues of sexuality, right? It's a very difficult topic to touch on. And I think it's very difficult to speak about, put it in one way, to sex without a sneer, because a certain kind of a jokiness which comes in. Funnily, where I got this insight from was actually Justice Shah in the Delhi High Court here.
Delhi High Court.
When the government counsel was making some particularly obnoxious comments at that time, right, about saying something like, I mean, if I remember the character of the comments, it was something on the lines of the anus is a place meant for excretion, your lordship, they do it from here, and that was the nature of the comments, right? And Justice Shah came in a very beautiful way. He said, counsel, a range of ways in which you speak about these issues, and I think a lot of the way prejudice operates is through what he called these water cooler conversations, right? So he said that it's important we step away from that. I thought it's a very beautiful insight in a sense, right? Because even as people are viewing this webinar, I think the point is this, right? We can attend webinars, we can be a part of various discussions, but in terms of finally, when you're in your own particular space, in that water cooler with your friends, or in the cigarette break with your friends, what is the kind of viewpoint that you have? That's the important question. And I think that's the place where Navtej marks a fundamental shift, where it tells you that you can actually speak about sex and sexuality without a sneer, without a sense of disgust, without a sense of making fun, and without a sense of laughter, as it were, right? And that links you back to perhaps maybe the fundamental contribution of Navtej, which is you see the fact that the decisions people make about their intimate lives in terms of who they choose to love and who they choose to be with is integrally linked to the notion of dignity. Dignity, in a sense, is the other way humiliation. That we all know what the experience of indignity is when you're ostracized, when you're humiliated, when you're made fun of. And Navtej basically puts on board the idea that the decision you make about who you want to be with is integral to the idea of human dignity. And it's integral to the idea of human dignity because integral part of personhood. Who you are is also fundamentally defined, or not fundamentally defined, is defined by who you love. And that's so integral to who you are that if somebody's going to make fun of you, laugh at you, humiliate you, ostracize you, have the watercolor conversations about you behind your back, then that's something fundamental to the idea of human dignity and personhood, which is the ideal in the Constitution. Again, one simple point in the Constitution, if you look at the preamble. The preamble says fraternity assuring the dignity of the individual. And if you go back again and ask the word, why did the word dignity enter the Indian Constitution? You'll get the answer that the objective resolution, which was initially moved, didn't have the word dignity in it. It comes in later due to Akash Singh Ratho's contention, is Baba Sahib Ambedkar's intervention. Again, you ask the question, why was dignity so important to Dr. Ambedkar? And you get the answer, that it's an experience of humiliation and ostracism, which says that this is fundamental. Regardless of what economic benefits we may gain, we must be treated as full human beings. So I think if you're asking what is the fundamental, the core idea of Navtej Singh Johar, it is the idea to deal with all persons with the understanding that the full persons entitled to full rights under the Indian Constitution, and particularly the right to dignity. I can go on, but I think I'll stop with that, Alex, Anthony, for you to come in with any other thoughts.
No. So Arvind, that I think you set the sort of context really, really nicely in terms of why Navtej is what it is, and why is it talked about and celebrated today, and will continue to do so for many years. So Arvind, the few things that I think which you brought out really nicely in the Right to Love booklet. So I think you've touched upon the first thing that I really wanted you to, which is sort of the tonality as well, right? I mean, the way it's written, the tone of the judgment is as important as the content that it seeks to convey and what it seeks to say.
If you go to the question, it's a very important question. As lawyers, we've all read many judgments, and I always felt that reading Navtej was a particularly unique experience, even reading it as a lawyer. And the reason I felt that is, if you start with, say, Justice Indu Malhotra's opinion, she begins by saying, history owes an apology to LGBT persons and their families for the violence and the ostracism that they have suffered. If you go to Justice Chandrachud's opinion, he makes a point that we may not be able to right the wrongs of history, but we promise a different path going forward. He makes the comment that civilization has been brutal, referring to the way it's dealt with the LGBT community. So from this, I think you get one particular insight, that is, we're used to judges speaking from on high, telling us what they think. We're not used to judges telling us that we are complicit in a certain situation of oppression. There's a certain way in which the judges acknowledge, with a certain sense of almost humility, the fact that we've been a part of an oppression. So that accounts for the remarkably different tonality of the judgment, where the judges are conscious of the fact that we have a lot to learn as well, and we have a long way to go in terms of how we change the way society thinks, right? And that's conscious, that's there throughout. For example, I'll give you one more insight during the hearings, where the justice, when the question was, will this judgment change things? Was the question which came up, and Justice Chandrachud's response was, says we have a long way to go. The fact that we come up with this judgment is important, but how will it change things in rural areas and other parts of the country, etc.? So there's a certain way of acknowledging that there's a long way to go, and that's the humility which the judgment has. And if you read Justice Nariman's final order, again very interesting, he says that the order says that the government must popularize, using all the media at their disposal, the fundamental principles of the judgment, organize training programs for both the police as well as state officials on the principles of the judgment. Again, what that indicates is this is not the final answer. This is a first step, and we still have a long way to go. And that's the humility, or that's the tonality of the judgment, which is both rooted in humility, as well as in a sense of apology, as far as the LGBT community is concerned. The other principle I've alluded to is the entire question of dignity as it links to the notion of privacy. Again, I think if you look at it conceptually, that's a very important advance. We know the notion of privacy. We know the notion of dignity. How do privacy and dignity come together in the Navtej context? And here again, Puttaswamy becomes very important, because privacy is not, after Puttaswamy, anymore just zonal privacy. Privacy is also includes the respect for decisions you make about your intimate or personal life. So
Yes.
in that sense, privacy and dignity are integrally linked. So it's actually a development of the notion of privacy as beyond the zone, and development of the notion of dignity as including your right to make decisions about personal life as well. The other quick point I'd make is it alludes to the concept of both the transformative constitution as well as constitutional morality. Again, absolutely important concepts. Absolutely important concepts. Because again, for constitutional morality, the judges go back to Dr. Ambedkar's statement in the Constitutional Assembly, where it says constitutional morality is not a natural sentiment. Our people have yet to learn it. We have to cultivate it. So the point he's making there is that and Justice Narayan develops this very well in the judgment, where he makes the point that regardless of what the majority thinks, you cannot deprive the minority of certain fundamental rights. Yes. So it's a kind of a counter-majoritarian understanding of democracy. It's an understanding that in a democracy, a majoritarian democracy, majority rules. That's the end of the story. In a constitutional democracy, the judiciary has a particular responsibility to ensure that a minority are not deprived of fundamental rights. And that's the responsibility which is vested or cast upon the judiciary. Not just in this case, but again as a future-looking point in future cases as well. That's the other fundamental and important dimension. And of course, that's linked up to the idea of what the judges call transformative constitutionalism, which is the idea that we view the Indian Constitution as not just a tool for judges and lawyers, but for all of us. Again, you go back to what Nehru had to say in the Assembly debates. He makes the point this magnificent constitution, which are made for ourselves, has been purloined by lawyers. Right? So again, the point is, how do you restore the constitution to the people, or to the people whose possession it should be? Meaning to say that we need to inculcate a constitutional morality in the way we deal with each other. Again, going back to the point I began with, in that water cooler conversation, you need to have a constitutional morality in the way you deal with people, including LGBT people.
So I think the whole concept of constitutional morality is the one big takeaway from this judgment. Of course, I think all the judges have definitely quoted Dr. Ambedkar extensively, but it is clear that it's not. And I think the real, for a lot of us Indians, our view is that we are a democratic nation, which means each of us has a right to vote, and we elect our government, and that government can decide for us. But we also have a system of checks and balances, and I think that's really what our constitution has envisaged. That it's not just rule of the majority, but also rule in a situation where every individual has a right to their fundamental rights and right for that to be protected. And it's not just the sort of a brute majority that decides what is right and what is wrong. And that's where the judiciary comes in, right? With because they ultimately are the sole or the ultimate arbiter of or interpreter of what the Constitution is and what it stands for. I really liked a line, and it's not something. It's a statement that Justice Nariman made, and it's not even in. I don't even think it's in the order. In the judgment as such, but I think it's he says that Justice Narayan says that sexual minority is also in the order of nature, and he says that I think during the course of it's in the transcript of hearings. It's a very simple line, but it actually tells you that what we have been thinking all these years as something that is against the order of nature or is deviant behavior, etc. He's saying it takes all kinds to really make the world, right? And no one set of people really gets to say that, hey, this is what is within the order of nature and everything else is not. I thought that this particular statement of Justice Nariman's was particularly powerful. But anyway, we'll come back to that.
Can I have one point on the order of nature? Just on the order of nature. Again, if you look at Justice Chandrachud's opinion, right? He asks the question as well, what is the order of nature? And he says that in India, the order of nature is different from the order of nature maybe envisaged in the Western world. Because here the order of nature includes, for example, the fact that there's a caste hierarchy
Yes.
and the religious hierarchy. So against the order of nature will include intercaste, interreligious, but also same-sex relationships, right? So all of this will be challenging the order of nature.
So the order of nature is a lot more complex than what 377 envisaged.
And the last line he ends with, the right to love is not just a battle for the LGBT community, but it's a battle for all of us.
Yes. Powerful words. Arvind, before I bring in Shweta, I wanted a quick, sort of explanation of the doctrine of non-retrogression. It's a complex sounding, sentence or set of words, but in the context of what it means for the average Indian, what does it really mean? What is the doctrine of non-retrogression?
It's a great question. And actually, the answer to that comes from, I think, Mr. Shamdevan's almost spontaneous response. When we had the 2013 judgment, the point he kept making, he said, this is outrageous. How can the court take away rights which has been recognized for so many years? How can the court take away rights which you already have? And so that got us back to the drawing board and said, how do we translate this outrageous into legal language? And I think I'm thinking, I mean, it wasn't I don't remember finding this concept. I think the credit for this goes to, I think, Gautam Bhatia. So he was in the matter as well. And he found the doctrine of non-retrogression in international law. Wow. And that's where it came from, right? And so we found it there, and then we put it in the written arguments. Justice Mishra obviously picked up on it, and now we have principle of non-retrogression. And if you look at what does the principle of non-retrogression mean in simple terms, in Mr. Shandevan's eloquent beginning words, rights once recognized can't be taken away. You got rights, you can't be taking them away now. That's absolutely unacceptable. Was his almost visceral gut level response, which has had a legal formula in the principle of non-retrogression of rights. And if you look at the Ayodhya judgment again, Justice Chandrachud, he picks up on the non-retrogression of rights. Again, the point he makes, again, I don't know why he's not following through on that particular logic, but he says the principle of non-retrogression of rights means that if you've been worshipping in a certain place for a certain number of years, you can't now take that right away from you.
Okay, so, if I may put it very simply, Arvind, essentially you can't put the car in reverse gear after a certain point of time. You've granted the rights, the vehicle is moving forward, the country is moving forward in a particular direction. Rights have been granted to citizens, and you can't take that away once they have been granted. So that's essentially what the doctrine of non-retrogression means. And what it means for all of us ordinary citizens is that if you've got rights today, then the Constitution essentially guarantees that you will continue to enjoy those rights that have been granted by law, by the Constitution, by the framers of the Constitution, or what have you. Right? Would that be an accurate summary of what that doctrine really means for all of us on a day-to-day basis?
Perfect. Yeah.
All right. Wonderful. Thank you, Arvind. Shweta, I know it's been a while. Arvind was holding fort, and but we've got a lot out from Arvind in terms of the Johar judgment and what it really means. At least the objective of today's session is really, to leave behind, sort of nuggets for the average Indian, right? Not for lawyers. So don't worry, you're not addressing the lawyers. You're addressing the average Indian, explaining to them what their rights are under the Constitution, and of course breaking down the Johar judgment as well. So firstly, to bring you into the sort of discussion, what are your views? I mean, do you have anything to add to what Arvind has just said? That's first. And second, I'd love to hear from you on, you've been, you've seen a lot of these cases post Johar and the way they've kind of, the hearings and the judgments that have been passed post Johar. So your thoughts on that, as well as what you're seeing on the ground. But first, any responses that you may have to Arvind's comments a while ago?
Well, firstly, thank you for having me over. This is actually very, very exciting for me. And yes, to answer your question, I agree with everything that Arvind has just said. But just a small point in addition, when I was reading the judgment, and because Arvind spoke about the tonality of the judgment, and especially the apology that the judgments begin with, it sort of took me back to when they recriminalized 377. And it felt like a lot of the tonality was in order to correct what had been said. the fact that they apologized, I mean, they can't, as Arvind said, that they're not going to outright go and say that, yes, we apologize for that blunder and that judgment was a blunder. History owes an apology rather than, well, the previous judges. So there was that, the constitutional morality aspect. The earlier judgment pretty much said that just because you're a minority, we're going to take away all your fundamental rights, because essentially in terms of numbers, you don't matter. So again, rather than saying that, it's sort of ironing over that. Not that I'm taking away from the importance of what has been said, but there was a lot of ironing out on the blunder that was committed earlier on. So, and of course, like Arvind said, this is the first step. While the judgment has been celebrated, as it should be, because it's landmark, it's gotten a lot of conversations going, it's gotten a lot of activities going, it's still only a first step. I also understand that there were a lot of directions that were issued in the judgment in terms of sensitization, workshops, etc. I'm not personally aware of any of those having been conducted. I feel like while there was a lot of words used, and while the section itself was watered down, the impact that it should have had in terms of the other laws and other provisions did not permeate as much as it should have, because there is still so much reluctance from the general public, from the authorities. So in that sense, we have a very, very long way to go. You also asked me about what happened in the cases following Navtej. You would think that, something like this would, you would go out and say that, yes, now this is legal, you cannot hold me, you cannot hold this against me anymore. But the cases following Navtej actually have quite a different story to tell. I mean, we're celebrating a few years since the judgment, but as recently as 2020, 2021, and even now, we keep hearing about the harassment that the community is going through in terms of, I mean, to begin with, family. Most of these cases of missing persons, of habeas corpuses, all of these are initiated, all these FIRs are registered by the family against the community people. And even though the authorities are very well aware of this judgment, they still go ahead and register these FIRs. And then, of course, they go to court, and then the court has to clarify that, look, they're adults, these are consensual relationships. What seems to be very, very basic has to be reiterated over and over again. People have to go through the rigmarole of the whole legal system. And of course, it's not easy to go through this whole process just in order to ascertain your rights that have been granted to you now. And there's a whole, not everyone has the privilege to actually be able to initiate these proceedings in order to get the rights that have actually been granted to them. So, on ground, this situation appears to be fairly different. The struggle still seems to be as heavy as it was a few years ago.
Even though the struggle seems to be as heavy as it was a few years ago, there have been some changes, right? I mean, there have been some landmark judgments in recent times that I think the Madhubala judgment.
Yes, absolutely. I mean, Madras High Court is doing some excellent work. I mean, in terms of Sushma, like you mentioned, Sushma's judgment, where which was the judgment where they said that, conversion therapy is not legal, and issued a whole host of guidelines that have to be followed in terms of sensitization, change in curriculum, free legal aid to people of the community, and, not discrimination in terms of hiring policies. So that, again, initiated and began with the family of these two women who were cohabiting, filing cases against them, saying that, this is registering FIR. So then they had to go to the court. say that, yes, we are in a relationship, and then the court issued guidelines after saying that there is absolutely nothing wrong with the fact that these two are living together, and adults can have consensual relationships. So in but this is also as recently as 2020, 2021,
Yes.
right? So
Yes.
you look at what should have ideally happened. I'm not even going to the laws that should have changed. I'm not even going to what other rights people don't have, right? We're not even touching upon the other rights that you derive from other provisions of laws that will need to be changed to be in line with this judgment. So that apart, we're still talking about the fact that two people are having a relationship and are living together, and that is still an issue 4 years down the line. But yes, of course, it's really commendable, the fact that, the Madras High Court passed this judgment. Madhubala, as you mentioned, Madhubala was actually passed by Uttara High Court, Uttarakhand High Court, which is not, traditionally speaking, not the most progressive high court in terms of its judgments. But again, it's reiterating that it's a part of their rights under Article 21. So, but still fairly recent, again, 2020, 2021.
Fairly progressive, even though it's,
Yeah. And another one from Madras High Court, Arun Kumar's judgment, where a marriage, for the first time, marriage between a man and a trans woman was recognized, to say that the word bride under Hindu Marriage Act does not only mean a cis woman, can also mean transgender woman. And I think that is absolutely landmark, because it was registration not even under Special Marriage Act, but under Hindu Marriage Act. So, it's going into that foray of law.
So, I want to come back to you, Shweta, in a bit to discuss the Deepika Singh judgment with you. I think that's again very, very new, very recent. But Arvind, the Sushma judgment, right, where Justice Anand Venkateshan actually said that he admitted, and very unusual for a judge to admit that they don't know enough, right, and that he actually went for sensitization. He tried to learn more about the LGBTQ community. He tried to get more information about their lives, about their practices, what they are, and so that he was able to give a more sort of an order or a judgment that was more after he had been sensitized. So I don't know. Is that? I mean, it sounds like it's a unique, first of its kind of a judgment, right? I've not really heard too many judges who have done that in the past. He even sat down with the parents of the the two young women who had eloped, to try and make them understand why they should not indulge in any kind of retaliation or victimize the two girls. So your thoughts? I mean, do you see this as a? Do you think this could be a trend where the high courts sort of start to get play a more proactive role in not just passing judgments and orders, but also to kind of get people together to make them understand why an order is being passed, and to get them sort of on their side, so to speak.
Linked to this, Shweta made a very insightful point. She said that if you look at the apologies, the way the apology was structured in Navtej, it said history was an apology. The judges are not apologizing. It's an apology, right? So the point being that sometimes in the judicial discourse, only certain ways you can say things. And I think the point Shweta made is the judges work with that framework, and they come up with a statement which keeps in mind the fact that they can't go too far. But yet within that limits, they say history was an apology, meaning something else. And if you take that issue, the apology, and I would read Justice Venkatesh's order as taking the apology forward in totally unprecedented directions. And why it's so unprecedented is going right back to Shweta's point, is the judge puts himself in the position. He says, I don't understand. As Anthony, as you said, for a judge to say, I don't understand is remarkable. And you should see the transcript of the conversation he has with the counselor. We know this because it's there in the order, right? And the conversation he has with the counselor tells you what are the doubts. If you're an ordinary chap who has no exposure to the LGBT community, what are your thoughts? What do you think of as LGBT community? Why are you discomforted by them? You get all of that when you read the transcript. His fundamental problem, which comes out in the transcript. He says, I always thought when you say two women together, they're only having sex all the time. That's what I thought. And then after that, I realized through the conversation that actually they have a relationship with each other, which is as rich, as powerful, as moving as any heterosexual relationship. Or I don't know if he says as a relationship with my wife, but I don't think he goes that far. But he says as any other heterosexual relationship. So then you get a sense that he's beginning from the placing himself completely there, saying this is who I am, this is why I need to change, and from that he arrives at a realization that the problem which the community faces is a structural heterosexism in almost all parts, be it in terms of the medical establishment, be it in part of the police, be it in part of a range of spaces. So he comes up with a series of orders to see how all of this can change. Again, the point going back to Shweta's point is you can pass as many orders as you want. How do you transform things at the ground level? That's the question of activism. That's the question of civil society organizations, people coming together and saying, hey, this is the order which is passed, going to that particular prison authority, saying this is the order which is passed, can we implement it? Again, going back to Navtej, the problem is we haven't gone to the union government saying this is the order, Justice Narayan, implement it. Right? We haven't put forward a campaign demand saying implement the directions in Navtej Singh Johar.
It's a bit like, to use an analogy that many are familiar with, post Vishaka, I think in post Vishaka, the Supreme Court had directed the government of India to pass a law to protect women from sexual harassment at the workplace. But I think it took more than 10 years before, or 15 years before the law was ultimately passed. I think we are in a similar situation here. Maybe civil society needs to constantly petition the government to sort of at least create awareness. And you don't have to change the law right away for what. It would be great if they did it to allow for same-sex marriages, civil rights, all of the civil unions, and so on and so forth. But at a minimum, let's at least take baby steps towards removing a lot of the biases that are prevalent in the minds of people, and actually force the government to create more awareness with respect to the judgment and what it's really saying to the average citizen of India. Shweta, I want to sort of come back to you on Deepika Singh. You've always been sort of a proponent of, let's say, let's say, families that are atypical, right? That are not necessarily conventional. It's almost like the judges heard you, when they wrote the judgment in Deepika Singh, right? It's a beautifully written judgment, and it's fresh off, hot off the press, if you will, or what have you. But it's almost like they heard you and they said, okay, fine. Now we're going to expand the definition of family. Could you just share some thoughts in terms of what the judgment's saying and what it means really? I mean, for the layperson, in terms of I think the justices have used terms like atypical love, widening the definition of family, and so on and so forth. Very interesting. And I don't believe it's almost like Johar opened the floodgates, and now there's just the dams burst, and you're going to see judgments which are very, very progressive. Your thoughts?
I mean, it's written by Justice Chandrachud.
Chandrachud, yeah.
He sort of let his opinion on the matter be known. He also says in the judgment that the point of law is to make sure that the point of courts is to make sure that that law sees its day, that the distance between law and society is reduced, that that law progresses as society does. So, and he's also categorically said that the law must be interpreted as such, that when you're interpreting law, that it shouldn't exclude, and that it should include.
Yes.
Funnily enough, it wasn't actually a particularly atypical family in this scenario. It was the interpretation that was all wrong.
Yes, that's right.
In the matter, the lady who got married, who was the appellant, got married to this person who had 2 children from his earlier marriage. as it turns out, when the appellant wanted to then take some leave,
maternity leave, I think she wanted to take
maternity leave for her first biological child, that was denied to her on the ground that, oh, look, you've already taken maternity leave for the other two children.
Yeah.
The other two children were not her biological children, but even if they were, the point was that they denied it to her, saying that, oh, you've already taken the leave and now you can't, because this is inherently your third child. This is not exactly your first biological child. So now we can't give you leave. Now, when it reached the Supreme Court, Justice Chandrachud then went through reiterated the law, talked about how all of this be interpreted, that there must be purposive interpretation, and that while giving such interpretation, the courts must improvise. And it is in that context that Justice Chandrachud then said that families are not necessarily a man, a woman, and a child, that it could be domestic partnerships, that could be live-in relationships, that it could be queer relationships, domestic live-in relationships. I mean, while it's a great observation, and I'm really, really happy with it, because, it does throw limelight on it when someone of that stature, a Supreme Court judge, talks about it, then, it sort of legitimizes it in people's heads. The issue is that it's not binding, right? It doesn't really have a binding effect because it's a passing remark in the judgment. So it's not as if it's going to automatically change things for people who are in these atypical familial structures. For example, my own family, I'm not in a very typical family structure. So, for example, I have to go get an agreement registered, or for my house, for example. It's not as if I can take help of this judgment, but it's still great. It's still, again, a step in the right direction. But, till such time as the prevailing laws are not changed, till that time, these are still just words. And while they do a lot in terms of changing people's perceptions, they do very little when I actually want to go enforce that right. So yes, while reading the judgment, I know, oh, great, look, there's a Supreme Court judge recognizing that my form of family is also valid. There's not much I can do with that, practically speaking, when, for example...
Well, it's not the ratio of the case. So that's basically...
It's an arbiter. So, therein lies the trouble. These are passing remarks. They're great. It's still a step in the right direction.
It's almost like Justice Chandrachud is looking for opportunities where he can still bring in something progressive, and he can make his views known clear, and hopefully give something to maybe other maybe high court judges to use in judgments going forward, to say, hey, listen, I'm giving you something to hang on to now. And move forward with it.
Especially considering the fact that a lot of the same-sex marriage petitions are currently pending before the Delhi High Court.
Yeah.
Although at this point, it really should be a no-brainer after the Chennai High Court judgment saying that in Arun Kumar, where a man and trans woman's marriage was recognized after Nalsa, after Navtej, it should be a no-brainer. But because Center is opposing it quite vehemently, these are of course, even though these are passing remarks, they can definitely be used for argument. Yeah. I mean, the message here is still fairly clear. I mean, he is making his stand known. He is making it known that, yes, this is the path you should be taking. Because even if you look at it from early 2012, 13, since Nalsa happened, the law itself has been taking this direction of having a more progressive approach towards sexuality, gender, familial structures. It's how it permeates is a different conversation, and that's at a more ground level. But the way the law is progressing has been made fairly known.
In fact, it's interesting. I just get the feeling that the future CJI is signaling that this is the stance of the court, and I mean, you just go along with it, right? I mean, he's made it very clear where his thinking is, and how he would like the court to sort of proceed from here on. And he's got a fairly long run as CJI, I think 2.5 years or so. So we're likely to see a lot more in the coming years. So
Absolutely.
probably a good time for people who want to file PILs and get regressive laws struck down, or get some progressive judgments. These next 2.5 years are a good time for folks, I'm sure. Okay, great. Thank you, Arvind and Shweta. We're going to just take a quick poll here. Would request all the participants to just take 30 seconds, give your answer on the on the poll that's in front of you. I think the question is, how have films and other media shaped your opinion of the LGBTQ plus community? It seems like 85% of the people have been positively influenced by films and other media, and I think what 5% or 15% have not been their opinion has not been shaped. Okay, so my comment here is that in my view, Bollywood has had a lot to kind of probably a somewhat negative role to play in terms of how public opinion has been shaped over the years. And I'm talking about Bollywood from 20 years ago, not now. I think a lot of the movies that have been made in the last 5 to 10 years are very progressive, very sensitively handled. But and that's probably what the audience is referring to here. They're basically referring to the fact that the portrayal of the LGBTQ plus community in movies and media in recent times have been have shaped their views positively. And also, I noted that the question was not referring to Bollywood, but just said films and media. So it could also be films from around the world, not just Indian films or Hindi or regional language films as well. So just 30 seconds each. Arvind and Shweta, your thoughts on films, and are they how have they progressed in terms of shaping public opinion about the community?
I would have to agree with you, Anthony. The especially Bollywood, it's only in the recent last 3 or 4 years where they've actually made anything of substance. Before that, at least mainstream Bollywood was just very typical stereotyping.
Yeah.
The whole Bobby Darling narrative, which was simply just outrageous and mostly made me want to crawl inside myself.
Very cringy.
Very cringy, very, very cringy. These last couple of years have been pretty good. I think there was that one Badai Do, and
Badai was good, yeah.
The last scene actually got me a little emotional because they show that their biological family sort of pushing them to sort of have the puja together, because they're like, oh yeah, this is your family. And me and my partners looked at each other and we were like, I don't know when that will ever happen to us. But that was probably the only Hindi movie that I personally
maybe
liked.
you need to show your family's Badai Do.
I did very
maybe all of you need to sit together and watch it. Arvind, what about you?
Actually, at the ALF, my colleagues had done a short film, two minutes film called Brokeback Bharat, and actually there's a very different position from both Anthony and Shweta have taken, where the argument is, if you read Hindi cinema in a different fashion, you'll find fantastic scenes of male intimacy, female intimacy. All of that is there. It's not the main message of the film, but if you read it in a subversive fashion, it's there. And that is what people, the queer community, in times past, when there was no such films or we didn't have the current moment, that's what they relied on. The fact that it was there. So
this movie, I mean, this short film, 2.5-minute short film, Brokeback Bharat, is it
it's available, freely available. You can just look for it online. You'll
YouTube,
find
it's probably on YouTube then.
On YouTube, yeah.
Brokeback Bharat, that's interesting. I've not heard of it, but the name is very interesting.
I'm going to watch it.
Okay, good. Before we move ahead, I just want to quickly check with both of you. Everybody extols the virtues of Johar, right? But if there was something that you could change about it for the better, is there anything at all that comes to mind that Arvind, you or Shweta would, you've thought about it and said, this could have been better, this could have been handled better, or they could have made this point more, eloquently or more firmly, or what have you? Is there something that you feel could have been done, or do you think the judgment is perfect as is?
Yeah, see, for me, I mean, when Nas came out, 2009, I would have said you can't have a better judgment than that. But I think Navtej actually is a NAS plus. And that is to the credit of the judges. Why is it a NAS plus? Because the non-discrimination provision is much stronger. Just make a quick point on that. Why that is important is when you say Article 15 non-discrimination grounds of sex, what does sex mean? And as far as Navtej is concerned, sex includes stereotypes based on sex. So for example, I mean, the connecting link they make was a very powerful link actually, is to say that what is the problem with 377? Part of the problem with 377 is 377 promotes certain stereotypes about perceptions of the LGBT community. So if there's a perception of LGBT folks as unnatural, that comes from the law. So the law, the problem with the law is it encourages or it's rooted in stereotypes. That's a fantastic advance. The idea of apology, again, it's an advance, right? The idea of transformative constitution, again, is an advance. The idea of non-retrogression is an advance from NAS. So it's a good question you're asking. Perhaps the one point I would go much stronger on is to take forward the insight that they had, that this is only the first step. And how would they have come up with a more series of directions to the government, the way Justice Anand Venkatesh did as far as the Chennai court is concerned. He's taken forward Navtej. So Navtej could have potentially, that's arguably, had those points of what the central government and the state government should do to eliminate prejudice against LGBT persons.
That's actually exactly what I was going to say. That I mean, firstly, I wish it was decided sooner that the reversal hadn't taken place. But that apart, I wish there were actual directions issued while the section itself was watered down, and that's great because the people can't be harassed on the basis of 377. There's what next? Now what? Because what's the logical next step? The logical next step would be, how do I exercise these rights? Which of course would mean that there would have to be a series of changes made in other laws. And of course, that's an executive act, and not that the judiciary can do anything about it. But of course, it can start debates about it, it can talk about it, it can have, and those can have precedentiary values. Another thing that I do now in retrospect, and of course, I don't think anybody could have thought about this then, but a lot of the argument that the center is using in its affidavits in the whole same-sex marriage cases at the moment is that it's actually quite absurd. It's that Navtej talks about these relationships in terms of privacy, but marriage is public, and hence Navtej cannot be applicable, and hence the scope of marriage cannot be increased. It's absolutely bizarre, that logic. But I do wish that there was some discussion on how these relationships actually translate in life. They don't remain in vacuum just as relationships between two people behind closed doors. These are public relationships. Sometimes they want to adopt children. Sometimes they want to, go through surrogacy. There's a whole host of things. I mean, I'm not even going to the basics of the issues faced by the people in the community, like basic healthcare and discrimination. But I do wish that those things had been at least touched upon. I mean, there's only as much as you can do in one single judgment. But, since you asked, yes.
That's both of you. I mean, very, very good points. I mean, it's clear that Navtej is what it is. I mean, it is a level where I think improvements can be done, but marginally, I think, and incrementally, probably over time as we go along. Because as the judgment is today, I think it's really perfection in many ways of the word. It's done so much that I think nobody really expected, especially coming from the setback that we have had previously, the Kaushal judgment and all of that. So from that perspective, I think what Johar has done is obviously incredible, and I think even 4 years on, I think most of us find it hard to say what else could we do with it. Yeah, I mean, okay, good. So one other aspect that I've sort of wanted to, and I think Shweta, you've also already touched upon it, but would love to hear Arvind and your views on this. What should be the priority or focus areas be going forward, right? Both for the community as well as for the country at large. What should we be aiming for? Same-sex marriages, civil unions, um, benefits to accrue to all citizens, whether what their sexual orientation is or identity or what have you, or should the focus be more on sort of an anti-discrimination legislation? Because uh, it doesn't, what we have, focusing on some of these other aspects takes away from probably aspects of discrimination that a lot of Indian citizens face, right? And in India particularly, I think caste is one area where there's a lot of discrimination that is continues to be faced. And somebody who's at the intersectionality of both caste as well as sexual minorities, it's almost like a double whammy. So, any thoughts, that both of you have that you can share in terms of going forward? And I know that at some level we also have to be practical. We want to take small bites of the apple because at least that means we're moving forward. But there are also some of us who believe that that's not enough. We need to aim for more, and only then will we sort of really make progress. So I don't know if there's an answer to it, but would love to hear your thoughts.
I think it would have to be both, Anthony, in the sense that there is one aspect of, yes, changes in the existing provisions to make space for the people in the community, like you spoke of the personal laws, marriage, adoption, surrogacy. All of those are great, but they only deal with marriage and children and the familial aspect of it. But then there is the whole other aspect, which is discrimination, which is so basic, right? Because that's not something we go through at all. So to just concentrate on how family life of the people in the community can be would be to take away from something that's even more basic, that I shouldn't have to go through discrimination when I'm going to get myself admitted to a hospital, for example. So I think there would need to be anti-discrimination laws, absolutely. And then there would have to be changes made in the existing provisions to make space. It can't be one or the other, because there is no job guarantee. There is no, if we're talking reservations, then why can't there be horizontal reservations for people in the community? If we are talking about education, healthcare, all of those things, before we even get to the aspect of how they can have a legally recognized family system, we need to go a step further than that. We need to go to the very basic rights that the upper caste people generally have, the upper class people generally have, and they don't have to think twice about it. People in the community do. Police harassment, that's another one. That's not something that's died down at all. So, stuff that everyone else would generally take for granted, people in the community can't. So, unless those are resolved, which can only happen through anti-discrimination laws, what are we going to do trying to amend the other provisions? But also, that will not be enough. The amendments across the acts will also have to take place. They'll have to happen simultaneously.
Fair enough, Shweta. Arvind?
Just to follow up on what Shweta said, I think the question of basic rights is absolutely important. Maybe just take in terms of examples, right? If you meet a lot of our friends from the transgender community, especially the female to male transgender community in Bangalore, for example, you meet most of these guys. They're school dropouts. So you ask them, okay, what happened? Why? They've never been to college. So ask, what was the reason for dropout in school? And the answer is very clear. It's a question of bullying in school, either by your classmates or by the teacher, which will ensure that you can't access the right to education, right? So it's absolutely, as Shweta said, it's as fundamental, as basic as that. You don't have the right to the same resources or the same ability to take your life forward as everybody else. Like all our friends, very, very smart, very, very brilliant people. But because of the fact that they've not finished their school, so many employment opportunities are just ruled out. Even, for example, even the forum we're having, right? It might be very, very difficult to get, say, transgender people from a certain background here, because they're all school dropouts. So many of them are school dropouts. So I think it's anti-discrimination combined with a way of all of us begin to think seriously about the question of discrimination. as Justice Chandrachud says in Navtej, the Constitution is an essay in diversity, right? So how do we learn to accept that diversity, including diversity of the sexual kind, right? And that's a challenge, I think, again, going back to Ambedkar's words, it's a challenge of how do you cultivate constitutional morality, not just change the law. How do each of us cultivate a constitutional morality in that water cooler conversation, right? That's the most vital thing, right? It's a change not just about out there, it's about how you change in the way you make that space for people who are different in your own spaces. That's the important challenge.
There is severe lack of sensitization in the sense that the way the community is viewed, and of course media has a very huge role to play in that. So I'm really glad, Anthony, that you did that whole question, because a lot of the thoughts that we have and the way we talk about it, water cooler conversation, like Arvind said, is derived from how they're shown, right? How they're perceived in mass media. Now that mass media is beginning to talk about them in a more humane manner, is also when we're beginning to see a change where, people don't generally, I'm sure it happens, but, the teasing, the bullying is now being called out, is maybe hopefully getting slightly lesser, but the lack of sensitization it's not going to help with, even if there are laws.
Oh, fair enough. And in fact, as you both were speaking, a thought came to my mind, which I wanted to just run by both of you, which is basically, do you believe that, to paraphrase Ambedkar, Johar is just the topsoil of our country, where the sort of what is below is essentially not sensitized enough, right? And Johar is a great start, but it's really just the topsoil, and what's below is really not sensitized enough, and needs a lot more work to be done before we can actually say that we have come
It's
some
a bit
way.
of a complicated question, only because, if you look at, for example, work such as historians like Salim Kidwa and Ruth Vanita, they have this fantastic book called Same-Sex Love in India, right? And they trace out a traditional same-sex love in India from 200 BC, right, of the contemporary times. At times it's a dominant tradition, at times it's a recessive tradition, but it's a tradition, it's a worldview which is always present. It's there, right? So I think in some ways we have to see how we can harness the resources of our culture to make a case for greater acceptance of diversity, including diversity of LGBT folks, right? I don't want to make a blanket case saying that, our culture is irremediably problematic and homophobic, because that doesn't take us anywhere, right? We have to say that we have to work with what we have. Again, it's an important point only because how do people in rural areas live till today, right? They draw upon the resources of culture, be it Indian tradition, be it Indian culture, be it Indian mythology, to make a space for themselves. And that you see the Karga festival, a range of festivals around the country, really. So I think we have to, a lot more work needs to happen to understand what are the cultural resources we have to understand the lives of LGBT people, which is beyond the urban middle class sphere itself.
Got it. Shweta, any thoughts on that? Or
I'm sorry, could you repeat the question? I got disconnected.
No, we're just talking about, does more work have to be done really in terms of post-Johar, really? Johar, of course, is a nice, very well-written judgment that's laid a nice foundation for how we progress from here on. But what's below is essentially, mindsets and the ways of thinking that are that probably have deep-rooted biases. And therefore, probably a lot more work needs to be done before we can say that we have sort of accomplished something or reached somewhere.
While I was talking about how there need to be changes in law, and while Arvind was talking about how the perception itself is what is need to be changed, and we're talking about inherent biases, I feel like a lot of these come from the fact that there is no sex education in this country. Who's teaching kids about how to behave with people of LGBTQ community? Who's teaching them that this community even exists, or what they are, or that we're not deviant or perverts? Or like, if there is that perception of people of the community being a certain way, then that's coming from somewhere. Where is it coming from? Because I don't know if anyone is actively telling them, because there's a whole host of people that think this way, right?
Yeah.
So in my opinion, it comes from the lack of sex education, because when I was growing up in my school, all we had was anatomy classes. Nobody sat and taught
Biology.
us. I was shockingly old when I learned about homosexuality, and I was very surprised because nobody spoke to me about it. I didn't know it existed. So, I mean, and I come from a small town, and I'm very, very sure that other people who like me are from smaller spaces, because in metro cities, it's still slightly different. There needs to be comprehensive sex education that teaches you what these things are and how to behave with your fellow human beings when you come across people of different sexuality and, in different spaces.
Agreed.
I mean, without that, the change in law and is hardly going to do anything, because these inherent discrimination and inherent perceptions are not going to go away.
Yeah, so I think there's definitely a lot more work to be done for sure. And I think civil society needs to take it up with the government in terms of sensitizing the population at large. And maybe even if miracles can happen, we may also find that the government might be open to changing the curriculum or making tweaks to the curriculum so that children are sensitized earlier. And you don't like Shweta, you found yourself in a situation where you learned about homosexuality very, very late, right? So that shouldn't happen. That sensitization needs to happen at an earlier age.
Yeah, I mean, Sultan's judgment is actually an excellent example, because the direction is that, the curriculum be changed so that these things can be included and the kids can be taught. I don't know how much they've actually done it.
Post that, I believe, post the judgment, I think the Tamil Nadu government has taken steps to create awareness.
In fact, I think there was another judgment which said that the Tamil curriculum needs to change to include specific words for queer people.
Yeah, that's right. So, I think that's coming out of Justice Venkateshan's judgment.
Yeah, so I mean, that's a great move, because that happening at a local level is fantastic, because it's very easy to say these things in English, because these are already thoughts that have been articulated. When you go to a more ground level in the more interior of the country, it's a little difficult to express these thoughts in local language.
Agreed. Okay, good. Before we sort of begin to wind down our session, we have another poll. So the second poll is basically, have you ever spoken against someone's prejudice towards the LGBTQ community? So have you spoken out against a prejudice that somebody has carried against the community? Have you been outspoken, or have you never spoken? I don't know. I guess that's what we're trying to find out. Okay, so I think basically the results are kind of interesting. It's sort of even Stevens. The question was, have you ever spoken out against someone who's had prejudice towards the community, or who has been prejudiced against the community? And about 30% of the people have said that they've always spoken up. About 36% of the people have said sometimes, and another 36% have said never. So it's interesting. There is an outspoken section, which is basically the people who have said that they've always spoken up. And of course, then there are others that who sort of have sometimes spoken up, and then there are others that haven't. So interesting to know that. I think I'm glad that there is the section that believes in always speaking up, and hopefully we can convert the other sections into those that are outspoken as well. Shweta and you have really made this sort of very, very interesting and engaging, and I hope our participants have taken away a lot from today's session. Before we close, Arvind and Shweta, do you have any sort of last thoughts that you want to share with the participants who've been here before we close today's session?
I feel like there is a lot of sensitization work that needs to be done even in different professions. And I would say our profession to begin with. And I don't know what your and Arvind's experiences have been, but in my experience, law as a profession is actually extremely conservative, and where that's where it sort of needs to begin. Because I mean, if we are going to be at the forefront of fighting these battles and um, being the voices of of the community, then it's where it needs to begin.
Okay, so do you believe there needs to be more change in the outlook of the legal community?
Yes, absolutely.
Greater
It's a very,
sensitization?
yeah, it's an extremely conservative profession. While we go and argue and talk about all these matters at very, very varied topics, there's inherently we're still very old school. And I find that even in terms of, especially in terms of LGBTQ, I mean, you don't, of course, I don't see people openly sniggering, but you see it. These are very, very microaggressions. You come across them on a daily basis. And I feel like it happens more in the legal profession than, well, I don't have any other experience in any other profession, but from what I gather, when I see other people in their respective professions and how openly they talk about these things, it feels like there's a fair bit of distance to be covered. I don't know about what Arvind thinks and about other cities in India, but this has been my experience at Bombay Bar.
Bombay Bar, okay.
Yeah, I just want to comment on the. In fact, I was thinking of the poll you ran, Anthony, and the question that in a personal context, when there is a sense of discrimination which you see somebody else facing, do you respond or do you not respond, or how do you respond? I was trying to think of what the concrete example to that might be. And the story of this young man who I know, who's a gay man, who's telling me that he was working in a corporate sector job, etc. And US recognized same-sex marriage, right? That's 2014. And when it was recognized, the conversation, again, the water cooler conversation or the lunch corner conversation was, my God, in the US, today, homosexuals can get married. Tomorrow, pigs and dogs will start getting married. And that's the conversation which happened. So that's the point. Right? At that moment, what do you say? How do you come? That's the challenge, I think, before people who are not necessarily maybe activists, but who can do a lot in terms of making a more conducive environment as far as LGBT people are concerned every way. So I think that's why this point goes back to the fact that everybody has a responsibility. This bias, this prejudice is not about the state alone. It's about the way society thinks. And that's the Ambedkar point. So how does society change? How do our own ways of thinking change? How do our own ways of talking change? So there's a way in which all of us have a lot of learning to do on this particular point. So I think that would be the big takeaway for me, saying that, that let's not worry too much or only about the battle at the big level. Yeah. Let's start worrying about the micro battles, the small battles, which we can make life better for your colleague or your friend or other people that you love and know.
Arvind, I'm going to put you in a little bit of a spot, and I'm going to ask you to help frame a response for somebody who is in the situation that you just described, where somebody says, what next? Dogs and pigs are going to fly. What would be the right way to kind of, I know that a lot of the response that might come is very individual specific, right? It depends on the kind of person or personality you are, and you respond accordingly. But what's a nice dignified way to explain to that person that you have deep biases that need to be fixed, and you are so wrong? I mean, what would be a nice dignified way to respond to that?
It's a little like just another case, right? Going to meet a counselor and say, hey, how do I understand my biases? How do I understand where my biases are coming from? In that 5-minute or 2-minute conversation, can it be done? I don't know. But I guess the point you really want to make is when you talk about the question of marriage, you're talking about the right of two individuals to enter into an intimate relationship, intimate association. And two individuals should be without regard to gender, sex, or sexuality. And that would be the way you'd see this point. That's the abstract, that's the way I'd frame it, the abstract legal way. But I think what you're asking is a more personal, intimate way, that's where change really begins, right? maybe to indicate that someone that they know is also gay, and somebody that they know who's also gay who's married to somebody else. That's one another way of looking at it, right? If you look
Right.
at Michelangelo, look at Vikram Seth, look at a range of public figures who are gay, and who do you want them, or don't you want them to enjoy the same benefit of relationship that you have? Again, the line which comes across very powerfully is actually just as Leela said. She wrote a very, very beautiful open letter, which is on the review being rejected, on Navtej, on the
Yes.
social review being rejected, and she said, "What makes life meaningful is love, and
Yes.
to criminalize the expression of love is to perpetrate a certain kind of ostracism and a certain kind of humiliation."
Yeah.
So I think the point you'd make again and again is what makes life meaningful is love. So do you want to deny that right to love to one of your colleagues or your friends?
Friends.
The ground that that they don't deserve it because they're not human like you.
Well said, Arvind. And I think when you mentioned, every time I've read Justice Leela Seth's open letter, it never fails to bring a lump to my throat. Seriously, it's so beautifully written. I think also partly from the perspective of a mother, and as well as that of a very eminent jurist, and you can see them both coming together in the way she's used her words and the way she's written the letter. It's magical, really. We have a part two of our webinar day after tomorrow, September 15th, same time, 3:30 to 5. Three very, very sort of eminent speakers. I'm actually delighted that they have all agreed to be on our panel. Zainab Patel, Deepa Shankar, and Suresh Ramdas. So I would urge all of you who are there today on today's session, if you can make time for this part two, I can assure you it will be really, really worth your time. These are three very, very sort of eloquent, articulate speakers, and make their points beautifully. So I think there's a tremendous learning there for everybody. Before I close, I'm sorry, I think there were a couple of questions, but I want to just ask take up one question for both Arvind and Shweta, so that we've responded to that question before we close the call. It's a little long, so I'm just going to quickly go through this. Thank you for this session. I think Ashwini has asked this question. Thank you for this session. Circling back to something that Shweta mentioned about how changes are yet to be made at an individual or family level. Do you really think Supreme Court judgments in favor of the LGBTQ community will have any impact on how families perceive their children who belong to the LGBTQ plus community? That's part A of the question. Part B, can Supreme Court judgments really change the way the world looks at the community? Part 2. And part 3 is really, does rural India or 75% of India even read or is aware of Supreme Court judgments? Quite a powerful question, actually. I mean, are we all living in an ivory tower, or do these judgments really percolate down? Shweta, Arvind.
I'd maybe begin by saying that we've seen the battle against 377 as a socio-legal battle. And the people who've been part of this battle include a range of constituencies, from small towns, larger towns, as well as big cities itself. So there's a way in which, for example, this judgment, the language of the judgment speaks to a range of people. The judgment itself, I mean, the Alex Anthony referred to the book which we did in terms of the right to love. That's been translated into Kannada and Hindi as well, right? So the idea that more people understand that this judgment is absolutely vital. There's a long way to go. That I'm completely on board that part of the question. But the point I'm making is what is absolutely vital and important is a normative acknowledgement that you're a full citizen of this country. The value of that can't be understated or can't be done away with. And that's the starting point. Once you're acknowledged and understood that you are a full citizen, entitled to all the constitutional rights as anybody else, then the sky's the limit. That's when the battle begins, right? And again, I think the point to be made is to the person who asked the question, is this is a part of a social movement. This is a way in which change begins, right? You have to be a part of the change. You have to begin this process of saying that, no, I'm going to be a part of the battle, part of the struggle, and take forward the ideals and the norms put forward as far as this judgment is concerned. And does the Supreme Court judgment change matters at the ground level? My answer is yes, it does. Very concrete illustration I'll give you, very concrete illustration to a legal audience. This judgment has been cited in 41 cases by various high courts. And this, out of 41 cases, 21 cases are of same-sex couples or transgender couples, lesbian couples, running away from their home, pursued by their families. They've gone before the courts, and the lawyers placed Navtej Johar before the courts. And the courts have held that as you have individuals, you have the right to dignity, you have the right to equality, the right to be with the person that you love. That's what the courts have held, right? Including conservative courts throughout this country. That's a concrete illustration of change. The other concrete point is this judgment has been cited in courts around the world, including in Botswana and places in the Caribbean as well. So again, if you speak to activists there, they will tell you it's incredible. Huh? Again, as Indians, sometimes we have a blinkered view. We're the size of a continent. We can't see outside our own pond. We see that the world outside is looking at us and saying, if a conservative, traditional country like India can change its laws, so can we. So this judgment is an inspiration for activists, LGBT activists around the global south. In Kenya, in Uganda, in Ghana, in Trinidad, in Botswana, you meet people, they will say, oh wow, what a fantastic judgment you have. We want to get a judgment like that as well in our country. So the judgment unleashes hope. And hope is the most important thing that we can have.
Fabulous, Arvind. I'm speechless. You're absolutely right. Spot on. I think the way this judgment is actually gaining currency in a lot of other jurisdictions, in addition to our own. And when you know that the high courts are applying this even for people, and that's where the change is happening on the ground, right? When same-sex couples are running away or require the protection of the law and the court, it's the High Court that steps in and applies the Johar judgment to say that you are protected under the Constitution of India, and that's where real meaningful change lies. Thank you so much for that, Shweta. Last words from you before we close the session today.
I don't look at the judgment as be all and end all. It has a domino effect in the sense that does it change things instantaneously on ground? Maybe not, but it's a start. We've discussed that. But also think about it this way. Before the watering down of 377, people were getting caught under that provision. It was wrong to be homosexuals, right? So when it comes to people's families, while they may not accept it immediately, they're not obviously going to be running around with balloons in their hands saying, yay, it's been decriminalized. But what will happen is that the notion of it being a crime is at least done away with in law. I mean, after that, when we talk about mental changes, that's going to obviously take a lot more time. It's no longer criminal, right? So even in terms of the personal validation that you get that, yes, I am not doing something wrong. And in terms of the way your family views you. So while it may not be what they idealize for you, it is also not wrong in law anymore. So, it's a step further. How much more change it needs, we have a very long way to go. But what a fantastic start.
Agreed on all counts. And on that lovely, beautiful note, we can close today's panel discussion. Arvind and Shweta, thank you so much for joining, for taking time out. I know it's been, I think we spent almost an hour and a half or a little more on today's session. So thank you. We're deeply grateful to both of you for having taken time out from your schedules to make time for this session. And should you both have some time on 15th of September, do join us for part 2 of our webinar. I know the speakers there, so I can promise you a very interesting discussion. So do join. And once again, thanks so much.
Thank you for having us.
Thank you.